John in Highbridge, New Jersey. Hey, John, thanks for watching Free Speech TV. You wanted to talk about jury nullification?
That's what it's called. Yeah, I'm actually reading Michelle Alexander's book on the new Jim Crow, and my wife had been called for jury duty, and I wanted to explain to her that even if you think the person is guilty of the crime they charged, there's a process by which you cannot vote. I just was hoping you could explain that again.
Sure.
I'll take the answer off the air just so that I can.
No, it's fine. Stick around, John, because you may have a follow-up question. There's a catch-22 wrapped in here. The way that the law, or the way that the doctrine, I guess, has been interpreted over the years is that as a member of a jury, you are basically the highest court in the land for the case that's in front of you. You have Supreme Court's powers. It's kind of like in Judaism. You know, Sabbath is the holiest holiday, and it happens every single week. Local courts are the ultimate authority. So, as a juror, you have the ability not only to determine whether the person is guilty or innocent of the crime, but you also have the power to determine whether you believe that the law under which they are being prosecuted is a just law or even a constitutional law. And you can choose to ignore the law, or you can choose to ignore the person's guilt or innocence. Now, here's the catch-22. When you are sworn in for jury duty, the judge, in most cases, will ask, will you swear an oath, raise your hand and swear an oath, that you will decide this case based on the law. In other words, you will waive your right to determine whether or not the law is just. You will waive your right to jury nullification. And typically people don't even know about their right to jury nullification, but if they do, at that point, if you say, yes, I will render a judgment in this case according to the law before us, and then you go into the jury room and you say, hey, we're going to do jury nullification, blow this law up, you've just committed perjury, basically. You've just lied under oath. Now, I don't think that they can prosecute you, because I think that juries are basically immune from prosecution for things other than fraud. You know, if he says, are you related to the criminal, and you say no, and it turns out you are, you can actually, there's some serious prosecution for that kind of stuff. I don't know of anybody being prosecuted for exercising the right of jury nullification, but it is a ethical, if not legal, conundrum, because in order to get on a jury, you have to give up your right, at least 50% of your rights as a juror under the current system. And I think that the reason why that has become customary in juries, because if they say, do you swear you will, do this under the law? And you say, maybe, maybe not. I want to know what the law is. As a juror, I have the right to determine if that law is just. At that point, the judge will say, okay, you're discharged. You're not going to serve on a jury. And then you don't get to be on the jury. And this is not a good way to get out of jury duty. But I'm not advertising it as such. But do you see the kind of catch-22 here?
So if you even said that you were aware of the jury nullification, that would almost be a disqualification in and of itself? Every case that I've ever heard of, you get, not only do you get automatically disqualified, but anybody who's in the room with you who heard you talking about it will get disqualified. Gee whiz. Yeah. So, it's like, this is like grabbing high-tension wires. It's tread carefully here. John, thanks a lot for the call. I would suggest that you spend a little bit of time on the Internet researching the subject. It's called jury nullification. Somebody called earlier and asked me about jury nullification, and I pointed out that there is this odd catch-22. Jury nullification is the doctrine which has been part of the common law of the United States and, frankly, of England before the United States, that the highest court in the land is actually the local jury. And that you, as a juror, have the ability not only to decide guilt or innocence of a person based on the law, but you also have the right to decide whether you believe that this law applies to this case or not, or even if this law, the effect would be whether this law applies to this case. If you disagree with the law, you can simply say, I'm not going to enforce this law. For whatever reason. I don't like it. I think it's unconstitutional. It's against my religion, whatever. And that's called jury nullification. It's where the jury can nullify a guilty verdict or nullify a law, in effect. And I said that the catch-22 to this is that
when you're sworn in as a juror across the United States, the judge will ask you to raise your hand and take an oath saying that, I swear that I will judge this case as a juror based on the facts presented before me in the context of the law as it is explained to me by the judge in the jury instructions. Well, in doing that, if you say yes, you've waived your right to jury nullification, basically. You've given up half your rights as a juror. Half of it is to judge the person. The other half is to judge the case, the law. And if you say, no, I want to retain my right to jury nullification, the judge will not only kick you out of the courtroom, but he'll kick out anybody who heard you say that. Because in most states in the United States, defense attorneys are not allowed to say this to juries. If you guys don't like this law, you can, Trayvon Martin case, they could have, under jury nullification, the defense attorney could have said, well, actually, the prosecutor in the Trayvon Martin case could have said to the jury, if you don't like the defense that George Zimmerman is making, that he, under the Stand Your Ground law, he had the right to kill an unarmed kid, you can simply nullify that law. You can ignore the law and just find him guilty of murder or manslaughter. But see, in Florida, if you do that, the judge, as your boss, you're an officer of the court, and you're operating under the judge will, there can be some fairly stiff penalties, shall we say. There's one exception to this, and that's the state of New Hampshire. In the year 2012, year before last, went into effect, I think this year, 2013. Thank you. Went into effect 2013. The New Hampshire legislature passed H. Bill 146, which says, this is an act relative, and it was signed by the governor, an act relative to the right of a jury to judge the application of the law in relation to the facts in controversy. It's the title of it. In the year of our Lord, 2012, it literally says that at the top of the page. The amended analysis, this bill states that in all criminal proceedings, the court shall permit the defense to inform the jury of its right to judge the facts and the application of the law in relationship to the facts in controversy. So the court will permit defense attorneys to inform juries of their right to jury nullification. In fact, here's the actual language. 243.1, findings and intent of the general court. Under the decisions of both the New Hampshire Supreme Court and the United States Supreme Court, the jury has the right to judge the facts and the application of the law in relationship to the facts in controversy. The jury system functions at its best when it is fully informed of the jury's prerogatives. The general court wishes to perpetuate and reiterate the rights of the jury as ordained under common law and recognized in American jurisprudence, while preserving the rights of a criminal defendant as enumerated in Part 1, Articles 15 and 20 of the New Hampshire Bill of Rights. In all criminal proceedings, the court shall permit the defense to inform the jury of its right to judge the facts and the application of the law in relation to the facts in controversy. This act shall take effect January 1st, 2013. Signed in the year of our Lord, 2012, 9/5, September 5th.